Tere teile ka IIZI kindlustusmaakleri poolt. Meie oleme siis need, kes ostavad oma klientidele neid lahendusi, mis aitavad riske maandada, muuhulgas ka siis juhtimisriske. Ja see ei taha siin toimetada. Aga selline väike meeldetuletus võib-olla eelmise aasta konverentsist ka, kus me rääkisime sellest, et millised siis asjad on need, millega tegeleb just see juhatuse liikme vastutuskindlustus. Ja juhime tähelepanu just eriti sellele, et risk algab paljuski juba palju varem, et kõik need tegevused ja toimetused, mis eelnevad sellele, kui teie juures toimub mingisugune läbiotsimine, nagu siin välja toodi, või kui tuleb mingisugune nõue, arve e-mailiga, mis nõuab mingi kahju hüvitamist, et kõik see on tavaliselt millegi tagajärg. Ja risk on tegelikult palju pikem kui siis see, mida võib-olla me ajakirjast, ajalehest loeme. Siin eelnevate slaidide peal oli päris palju selliseid juhtumisi ära toodud, mis on juhtide vastutusega seotud. Juhatuse liikme vastutus on alati väga isiklik, ehk et siin on alati keskmes see füüsiline isik, kes peab kahju hüvitama, kelle otsa vaadatakse siis, kui midagi on läinud valesti. See võib olla väga arusaadav ja nähtav, aga see võib ka ilmsiks tulla siis, kui ettevõtte on juba pikalt kohtus käinud ja päris pikalt juba mingites vaidlustes olnud, aga siis järsku leitakse nagu see koht, et aga me ei ole nagu vaadanud, et kas meie ettevõtte praegune või endine juht on ka midagi valesti teinud. Tegime siin hiljaaegu ka enda klientide seas uuringu ja vaatasime, kui palju me ise oleme selle kindlustuslahendusega viimastel aastatel tegelenud, siis vastu eelmist aastat on kindlasti huvi juhatuse liikme vastutuskindlustuse vastu hüppeliselt tõusnud, et küsitakse päris tihti ja me päris aktiivselt räägime ka sellel teemal ja ka täna on väga palju saalis olijatel juba see kindlustuskaitse olemas. Ja miks see nagu on oluline ja miks see juhi kesksus on siin oluline, ongi just see, et kui lähevad asjad hapuks, et siis ei pruugi ettevõtte ja selle juhi huvid olla selles vaidluses samad. Ja kindlustuse põhiline eesmärk on seda juhti, kes on siis väga halvas olukorras, ennekõike siis kaitsta. Tihtipeale tähendabki see seda, et kaitseb ennast ühelt poolt ja teeb õiguskulusid ettevõtte ise ja teiselt poolt peab ennast kaitsma siis selle ettevõtte juht. Juhtide definitsioon on siin ka väga lai, et see ulatub nii juhtorgani liikmetest kuni ka teiste ettevõtte juhtivtöötajateni, kes juhtimisotsuseid teevad. Ja ametiasutuste uurimise puhul on väga sage see, et ettevõte siis tahabki võib-olla selles mõttes juhile osutada siin ja süüd võib-olla selle ühe üksiku isiku kaela veidi suunata. Ja see ongi nagu see koht, kus see kindlustus võib-olla sellele ettevõtte juhile on nagu kõige kasulikum. Ja põhimõte nagu ongi see, kui ettevõte nagu loobub sellest või ta ei saa mingil põhjusel juhti siis ise kaitsta ja ettevõtte juhil on vaja ise teha siis kulusid, võib-olla siis hiljem ka hüvitada kahju. Mõned näited siin ka, ehk et oluline ei ole nagu lõplik otsus, mis poliisi käima tõmbab, vaid juba selline esimene märk, et midagi on läinud valesti ja võib tulla nõue. Väga tihti see tähendabki mingisugust kirjalikku nõuet või mingit vaiet, aga ka näiteks mingi ootamatu kontroll ettevõttes. Mingisugune järelevalve menetlus algatatakse, väga tihti tõmbab see käima ka juhatuse liikme vastutuskindlustuse poliisi. Algatatakse mingi ülekuulamine. Praegu ka väga levinud, mille kohta me nagu peame päris palju nagu rääkima ja ettevõtetega aru pidama, on see sama erikontrolli meede, et üha levinum. Aga jah, väga paljudel juhtudel juba ka Eestis on kindlustuslepingu käivitajaks mingisuguse ametiasutuse tegevus. Ja kindlustuskaitse ulatusest mõne sõnaga ka, et mida nagu siis panna nagu riigiasutuste uurimistegevuse raames nagu tähele, ehk et vaata oma poliisi sisse, et mis on seal täpselt see definitsioon, kust maalt see algab, et kas see tähendab seda, et uurimine või kindlustuspoliis juba tuleb appi siis, kui see tuleb signaal, et mingisugune uurimine võib alata või see tähendab ikkagi ametliku uurimistegevuse algust. siis täpselt olen ka siin ära toonud mitteametliku või ka siis ametliku uurimise vahe, et vaadake, kuidas see defineeritud on ja kuidas nii-öelda see poliis siis käivituks. Pööra kindlasti või igasugustele välistustele tähelepanu, väga paljud neist võivad olla ettevõtte spetsiifilised, näiteks kes toimetab mingis keskkonnaga seotud valdkonnas, et siis tuleb pöörata tähelepanu, et kas sellised riskid ja trahvid ja tegevused on välistatud või mitte. Ja ka siis trahvid, mida hästi tihti küsitakse trahvide kohta, et kas siis kaetakse trahve. Kindlustuslepingud on siin väga erinevad ja kui nad katavad, siis nad katavad pigem nagu neid trahve, mida juht saab siis isiklikult, et mõned regulatsioonid võimaldavad seda teha. Küll aga mitte siis ettevõttele tehtud trahve, näiteks kui Keskkonnaamet teeb trahvi, et see peab olema ikkagi juhiga seotud, ehk et need esimesed slaidid, kus oli rõhutatud see, et selle kindlustuslahenduse keskmes on füüsiline isik, kes peab siis oma varadega vastutama. Kuna oli mitmeid küsimusi, et jagage ka kogemusi erinevate kindlustusjuhtumite kohta, siis kahjuks me võib-olla väga ei taha avada seda, mida meie klientidel on siin viimastel aegadel juhtunud. Ja sellepärast ma kutsusin appi meie hea koostööpartneri Peter Schlambergeri, kes siis räägib mõnedest juhtumitest, millega siis temal on kas teadmist või kokkupuudet. Peter, over to you.
Thank you very much, Helen. Helen, sorry, just here?
Yes, green one.
Thank you very much. And thanks for everyone for joining. And thank you, IIZI and Sorainen, for another invitation. Thank you so much. Great to see so many of you turning up, some familiar faces, some not so. But it seems like D&O is gaining momentum in Estonia as well. And it is, from our experience, is becoming part of the standard corporate insurance buying behavior and part of the good standard of corporate governance. I'm here today to bring some kind of anatomy of some of the live cases. And by the way, the first two are not something that we are intimately involved in. It's all in the public domain, so I can actually discuss them. The last one is actually something that is very intimate to us. So it's a case that we're going to be discussing. It's not actually from Estonia, so we're not going to be talking about Estonian live D&O notifications, but I can tell you we've got quite a few. And they all seem to be sharing like a common nexus, like many other D&O claims that we've got elsewhere in Europe. So I wanted to just kind of talk a little bit about the overall dynamics of how those notifications come in, about the mechanics of how the policy responds, and as to at what stage we get involved, at what stage brokers get involved, and obviously we expect the clients to be involved very, very intimately and actively in help us, rowing against a third party, if you like, so that we can have a good outcome for all of the stakeholders involved. So 3 cases I want to bring up today come from an array of different regulatory arenas. All of them have ended up with civil litigation for damages, against the management boards. But actually they stem from investigations of governmental bodies. And I wanted to bring up 3 very different cases. The first one for price fixing or antitrust breaches. Second one for ESG type arena breaches and deficiencies in the overall controls of the company. And the third one is actually public procurement breaches, which is something that we have seen actually from Estonia as well. But to take on the first one, I'm not sure how many of you know, but I'm assuming quite a few. Villeroy Boch is a bathroom equipment manufacturer, a German one, which has been fined 70 million euros for price fixing allegations back in 2010. And the interesting case here is that Villeroy Boch's shareholders and the company have decided basically trying to recoup some of those 70 million from the management. Yeah, it was a very substantial fine, which comes to the bottom line of the balance sheet. So the company has decided to pursue the claim, basically a civil demand for damages, to recoup that from the CEO of the company and the 4 prior board members altogether, right? Now, to cut the story short, they failed, and it's a big precedent case, certainly for Germany, because the court didn't allow for the fines, civil fines that were imposed on the company to be recouped against the management, yeah? So they said that the only, parties that should really be fined is the company and indirectly the shareholders of the company, right? But the interesting case here is it's twofold cases. So roughly between 60 and 70%, depending on the year of account, of global D&O claims start with a regulatory investigation. Just to make sure we're not talking about routine periodic investigations, we're talking about formal investigations. This is something which is not standard, right? So the governmental authorities investigate something where they have a suspicion that something's been done wrong. And in this particular instance, when you have an antitrust case, very regularly, it won't only be the company that gets investigated, but very often it's targeting the individuals of the company who have, or maybe alleged to have been involved in the actual price fixing case. And so there is, from a D&O perspective, the particular point where you start looking at a policy closely is when the individuals get targeted. Because part of what the policy does, it will start picking up legal representation expenses in a governmental body investigation. In this particular case, anti-monopoly, antitrust regulatory authority. So what you will do, you're going to start paying the lawyers for legal representation at regulatory investigations, i.e. meeting, hearings, or interviews. And typically, those are lengthy processes, and they cost a lot of money. Yeah? And there are multiple board members. Here in this case, there's 4. So there's a multiplier effect because they're all going to say we're in conflict between each other, so we're not going to be using the same law firm, right? So you've got a multiplier effect. Very often to that, not in this particular instance, there's a criminal investigation side by side. Very often, not always. Yeah? And in this particular case, not only you've got legal representation expenses, which the company also tried to recoup back from the management board. And in this instance, there's actually a figure to it, which is 143,000 euros. Yeah? But I also wanted to recoup the fine, which was a lot more substantial. In a civil lawsuit, you start incurring defense costs. And this is also ground up from a D&O policy perspective. The dynamic is very important because when the company sues the manager, the policy will start responding from first euro onwards. So it's a side A claim, not want to bore you too much with that, but just means that there is no indemnification which is possible by the company because the company is on the other side and is suing the individual. So the policy will respond in both cases from first dollar onwards. So the second case is much closer to Estonia. It's a Polish case. You may or may not have heard it. It's a power plant that was supposed to be built. It's a coal power plant owned by Enea and Energa, so it's a joint venture. It's called Ostroleka. It's a very substantial investment that the company was pursuing in spite of being warned on several occasions that it's, from an investment perspective, it's an indefensible investment, right? Because in 2008, the price of the carbon coupons in Europe was going up through the roof. Cheaper alternative energy resources, were available to the management, and overall, from a return on investment perspective, was really not viable. So the management, in spite of being targeted by an environmental group called Client Earth, who have initially written with the lawyers to the management of the company and said, don't do it. Yeah, don't go in, don't make an investment because it's indefensible, right? It doesn't make any sense. They went and did it. So Client Earth pursued a lawsuit in 2019, basically managed to stop the project. So the company has already invested more than 1 billion Polish zloty at a time, had to write down that complete investment. What happened? They had an authority called Super Audit, it's a governmental, kind of a body in Poland, started formal investigation proceeding, against the company, and realized that actually it was the manager's liability, to do for a lack of proper due diligence on the investment proposition, and has, in its findings in 2021, published, sent to the shareholders of the company, and the company has proposed that the company and the shareholders pursue litigation against the former management. So they went against the supervisory board and the whole board that was responsible for the investment. Yeah, the litigation is still pending, but the company is trying to recoup more than $150 million from the management for the failed investment and for failure to supervise of the investment and for the lack of due diligence, prior to actually deciding on an investment. So the policy again, in the initial stages, it would start picking up legal representation expenses in a regulatory investigation of the super audit office. Yeah? And if it comes to a civil litigation down the line, it will start picking up defense costs and potentially, and here the big question is really, which does happen, believe it or not, how much limit this company buy. One of the key kind of observations for everyone in the room when you sit with your broker and discuss, buying the D&O policy or renewing the D&O policy is how much limit are we going to buy? Now, when you make 1 billion Polish zloty of investment, or quarter 1 billion euros or 500 billion euros, now how much D&O limit do you have to buy in order to protect the shareholder's asset against that? Because here, 1 billion got written down. So who takes the hit? It's ultimately the shareholders, because you wipe it off from the shareholders' equity, right? It's a loss to the balance sheet of the company. So how much do you buy? And that is a very, very key observation, because when you've got 5 board members, 5 supervisory board members, they all have to split the limit. It will cost a lot of money. It will take forever to get resolved. There's going to be all sorts of expert witnesses that cost a fortune, and it will probably take 5 to 10 years before it gets resolved, before we even get to an indemnity payout. Yeah, so before the court says, okay, that's what you need to pay as damages, right? Or before it's an out-of-court settlement agreement. Yeah, so either way, it will cost a lot of money to get resolved. Yeah, and policy will pick up legal representation expenses in a formal investigation, first dollar onwards, defense costs in a civil lawsuit, first dollar onwards, and potentially any indemnity if there is any limit left for that, right? Because don't forget, these policies get eroded very quickly just on the basis of defense costs and legal representation expenses alone. With the legal fees inflation, it's even if you're renewing a policy, it's time to revise the limit, yeah? Or consider to revise the limit. I'm Slovenian by background, from a very small country. Regrettably, I can't say we're not litigious. It seems like in Slovenia we really like suing each other, right? With the help of professionals, the lawyers, getting them involved. And we've got a live case. I can't really talk too much about that. It's an energy company. It's 100% state-owned, yeah. And the way the case started, it's actually a competitor that was not elected at a public procurement has filed a lawsuit at the Public Procurement Revision Office, which is a national office responsible for auditing all of the public procurement rules, whether the rules have been adhered to. And they basically said, in essence, that 3 of the public tenders that they've bid for were pre-set for a bidder. Yeah, so they said, when you've announced the public tender, you already knew who's going to win it, right? So, and they've complained. So they also went to the court, because that is the only way to appeal against the ruling of the Public Procurement Office. So we had to start, because they were also targeting the individuals of the company, we had to start paying the defense costs for these people. Not legal representation, because in the court, it's defense costs. So incurred in that short space of time for 3 individuals, about 125,000 euros worth of cost, which took about 2 years. On the back of the findings of the court suggested to file a criminal complaint against the CEO of a subsidiary plus 3 board members of the main company. And in parallel, so the company has decided to file a criminal complaint. So we're now basically have 4 individuals, 4 separate law firms, working on a criminal complaint. Plus the company in parallel is trying to recoup, 4.4 million worth of damages that have been caused to the company as a result of 3 failed public procurement, plus is probably going to be initiating another special audit to revise all of the dealings of that particular board for the past 5 years, which is a statute of limitation for anything civil in Slovenia, so you can start recouping. And so the policy, again, covers all of that, typically from first dollar onwards. There are some instances where the company decides to indemnify its board members, not when the company is the plaintiff, but when there's a third party pursuing, litigation or investigation against individuals. We're typically talking about governmental bodies, i.e. regulators, governmental agencies, police, special investigation police, or when it's competitors pursuing. Don't forget, we've got some very large European D&O claims that have been initiated by the competitors of companies. So yeah, very quickly in terms of the anatomy of the case and how the policies would respond, as I said, don't forget, D&O doesn't only cover civil demands for damages, which everyone is focusing on, of course, because they're very large, attract a lot of media attention, but the frequency is in the investigation, formal investigation of governmental bodies, regulatory authorities, governmental agencies, police, or other enforcement. Thank you very much.
Thank you, Helen. Thank you, Peter. We have 2 questions which have been submitted. First of them was about, are there any differences in insurance coverage perspective if a person is in board of a company that operates in multiple jurisdictions?
I would say not. No, because yes, the policies actually has to be compliant with Estonian regulation, but it applies to the policy itself and how policyholder and insurance company cooperate. But there are so many companies who operate in so many countries, and if they are legally liable for any damages, this regulation kicks in.
Can I just compliment so that where the dynamics change from an insurance carrier's perspective is that when you've got multi-jurisdictional exposure, you're talking about the multiplier effect on the costs. Yeah? So you can't have the same law firm representing you. Well, it can be the same law firm, but maybe different kind of a law firms of the same law firm in different countries. Yeah? So you can have that. But you're going to get a multiplier effect because those board members need to defend themselves or being represented in multiple jurisdictions at the same time. And sometimes being involved in more regulatory arenas than just one. I mean, don't forget the large Siemens case. It started as a corruption. It evolves into something else, and then it goes into antitrust. So there are multiple arenas, so it's a multiplier effect. So you start paying defense costs for all of these individuals in the individual countries. And let's not forget, not every country has got the same kind of a monetary dynamics in terms of the legal expenses.
And the second question was about the retroactive dates. Are there any limitations, basically, for retroactive dates? How far back can you go with the retroactive date, and how much more costly would that be if you want to have a retroactive date on your policy?
Let's say that former management is always covered backwards as well. But it's very different from policy. I have seen unlimited, I have seen 5 years, 6 years. So it depends on the insurance policy. But yeah, if you want to like full coverage for the management decisions, it can be rather expensive. It doubles or triples your insurance premium, highly likely.
Peter, anything?
This is an underwriting consideration, so each risk is different. It depends as to if you come to us with the legacy issues, then maybe we're going to have to really look at that and maybe see whether we can ring fence the exposure. Typically, I would say, if it's a clean-cut risk, generally speaking, yes, unlimited retroactive dates so that the management that buys don't really need to worry if potentially something that they didn't know at the time when they were buying, they did wrong, and then there's a litigation, it should typically be covered. But there are different kind of risks that come to us, and the more complex stuff, it's really subject to discussion between the brokers and the underwriters as to how flexible we tend to get. Yeah.
Okay, but that's it. Thank you, Helen, and thank you, Peter, for the presentation.
Thank you very much.